234-177.
All right, Ms. King, you have been reminded, but I'm just going to remind you on the record, you remain under oath. Mr. McFarland?
Just to let the court know, I did locate the documents which were filed upstairs. I am not going to use them today, and I have no further questions.
Thank you. Does anyone else have questions for this witness, beginning with Ms. Thomas?
No, Your Honor, thank you.
Mr. Brooks?
No.
Ms. Underwood? Thank you. Thank you for your testimony. You may return to your seats. Anyone else you'd like us to hear from for purposes of the initial disposition, Mr. McFarland?
No, thank you, Your Honor.
All right, Ms. Underwood?
I have no witnesses.
Very well. As it relates to comments that you may have on the initial disposition, Ms. Thomas, and I think we do need to address the Native American heritage piece for not only for both parents, really.
Yes, Your Honor. I believe that it was Ms. Miller who indicated some Cherokee heritage. I believe that the ICWA documentation has been sent out. I do not have returned green cards at this point in time, but it is something that the department is going to be following up on. If you would like testimony from, I believe Ms. Kelly or Mr. Farian would be the individuals to ask, but based on my review of my file, I am confident that's where we are.
All right, I just need copies of the inquiries, the certified mail receipts, and any green cards or letters that are returned. So it's just, I'd love to have them as soon as possible so I can stop asking.
Okay, yes, Your Honor. I know that we are still in the pretrial phase for Mr. King, but Judge, I think we need some court oversight here in a few regards. So one, I guess, as relates to the initial disposition for mom, we are asking the court to adopt that case service plan and enter it as an order today. We are also asking the court to order that the children undergo a trauma and bonding assessment. Per policy, the children need a screening level, the trauma screening level of 11 or higher, and they also need to be engaged in services that are not working. Given that the children are young, they don't have a history of services. We just need that order to ensure we can get that referral done. I believe that the bonding assessment would be sufficient to address recommendations on parenting time. At this time, we are asking the court to suspend Mr. King's parenting time. I believe that his behavior, and I frankly have recommended to the agency to stop parenting time. There was some concern about the language in our prior order, whether it meant that each parenting time could be suspended or that all parenting time could be suspended based on any dangerous or concerning behaviors. But I am asking at this point that all parenting time with Mr. King be suspended for all of the children, that no contact be there pending the return from the trauma assessment and bonding assessment. We do understand that obviously during the bonding assessment, there would have to be contact. I think that it would be prudent of our team to confer with the team providing the assessment to ensure safety measures are put in place, whether that's having law enforcement on a standby or additional hands there to assist with the children. Furthermore, we are asking, I know that both Ms. Miller and placement are dealing with PPOs in their own regard, but with this court having jurisdiction over the children through Ms. Miller and the removal, we are asking the court to also make that part of the order that there's no contact period, that dad is not to harass, contact, or in any way threaten the children, the caregivers, or mom. And we would also ask the court to order dad to be respectful to the workers. I think frankly, their job description doesn't include having to deal with such accusatory and argumentative behavior from parents. It is not our caseworkers' fault that the children are in care, rather the parents, and is the responsibility to address those conditions that cause the children to come into care. And there should be some appreciation for the people who are caring for their children and making sure that they have a warm, safe home, food, clothing, and their medical needs are met. As relates to the pretrial, Your Honor, and I think that this is also relevant moving forward in the case, we're asking the court to additionally enter a protective order that would allow us to bifurcate court reports and to eliminate the contact information for Ms. Miller. I think given the severity of the domestic violence that this family has endured, the behaviors by Mr. King, that is also prudent. And if this court is so inclined, I know that there are some concerns about whether some of the behaviors that are very concerning from Mr. King are induced by any drugs or substances. We would ask the court to order him to undergo a drug screen today before leaving. Thank you.
Please stop with the behaviors, Mr. King. They are disruptive to our proceedings. Thank you. Comments in closing, Mr. McFarland.
We support the position of the agency, and my client wants to be ordered into the case service plan.
Thank you. Mr. Brooks, any comments today?
Well, this is not technically about my client, but there's been a lot of ground covered here, all negative about my client, and I want to cut off his parenting time. And my only response to that is I have, at the family team meeting, witnessed the lack of effective communication between my client and the department. And I appreciate, and I've explained to my client how irritating it is, his habit of absolutely talking over people at every sentence they say. I get that. I have the same reaction. However, that is not the same as talking to kids who are the age of his kids. And he is not arguing, I'm sure, with his children, particularly about anything involving this case. Dad, I think we should be in foster care, and I think they're not saying stuff like that. They're not saying that Dad's got issues of his own. And I don't think there's been any evidence of him threatening his children at visitations, either verbally, certainly not physically. And I don't agree that he should be cut off from his visitations. Is he irritating? He is. He knows he's irritating. And I've told him that in plain English. But I don't think it has anything whatsoever to do with his kids. It has to do with his inner relationships with the outside world. And his personality can be grating. I admit it. He'll admit it. But he's not dangerous to his kids.
Thank you, Mr. Brooks. Ms. Underwood?
Yes, Your Honor, thank you. I would echo the words of Ms. Thomas. In general, I believe that it would be appropriate at this time to request drug testing today. I would say it's reasonable for both parents to be tested. I don't think it would hurt anything, and I think it would provide some insight as to what is happening in this case. With respect to parenting time for Mr. King, I think it is appropriate to suspend visits based on his conduct, not only today in the courtroom, but also in the family team meeting. I was very clear yesterday that we couldn't get anywhere during that meeting because of his behavior and his lack of consideration for others. And it absolutely does harm the children if he's doing those, if he's expressing and displaying those behaviors toward others in the presence of his kids. There has also been testimony that Mr. King has been inappropriate with the things that he is saying, talking about the case, and not respecting the parenting time guidelines that had been attempted to be relayed to him at family team meetings. There's a lack of accountability on his part. Mr. King doesn't believe he did anything wrong and that it's everybody else's fault. And I think that it's clear that, again, these children need a safe place that is free from his inappropriate behaviors until they can be addressed. So I believe that parenting time, it's appropriate that parenting time for dad be suspended until a psych evaluation happened for him and also bonding and trauma assessments happen with the kids. I also believe it's appropriate with respect to the oldest child that those visits be if they are to be ordered, that they be supervised very closely and that there not be any discussion with respect to this court case or anything happening during that time. I would also ask that phone contact be eliminated or closely monitored if it were to be ordered. I had spoken with the placement, and there have been at least 2 instances where Mr. King has driven by her home and either revved the engine very loud and then peeled off, or went by honking the horn and just disrupting the children in the placement. I believe it'd be appropriate for a no contact order to be entered in this case, wherein Mr. King's not to make any contact or follow or even drive by the home of the placement in order to protect the children and the placement who is opening her home, or they're opening their home to these children and helping provide stability and consistency for them during this traumatic time. Thank you.
The court finds all interested parties are given notice for purposes of the pretrial as it relates to Mr. King's case and the initial disposition as it relates to Ms. King's case. As it relates to the disposition, the court's reviewed the case services plan. I do find it appropriate, and it will be part of today's court order. The no contact between the parents will remain in place. We'll look for Ms. Miller to continue to engage with her parenting time and the needs of the children and her case services as she has been, as also to continue looking for housing and some other indications of stability that would alleviate the risk of harm associated with returning the children to her care. There's also clearly a need for some parenting education, observation of the bond between the mother and the child, trauma assessments to identify any additional limitations that children may have, as well as additional services that may be useful to them based on the information that I've read in the court report and listened to on the record today. The children were feral, to be frank. They were unfamiliar with bathing showers, eating food with silverware. As Ms. Brinker described, also the placement described in the report, kicking it, biting, uncontrollable behavior. Use of silverware was foreign to them as well. Potty training is an issue. So these children have clearly demonstrated very obvious indications that they have been raised outside like animals, frankly, and it has caused them a lot of real problems that are going to continue to be real problems as they move into the next phase of life, which is a formal education setting. It's imperative that Ms. Miller show us that she is willing to dedicate the next 6 to 9 months to finding a stable environment and learning how to raise her children in a way that will allow them to be successful in our culture and in our climate, frankly. It's snowing this morning on my way in, right? There's a lot of traffic out there. There are very practical implications for a lot of the things that we've observed here, and it's been obviously very difficult for caseworkers, for the placement, and for everyone who's tried to support this family. I have 2 additional bailiffs in the courtroom this morning based on the dynamics that are being observed in the courtroom this morning. So I can only imagine that the behavior and what we're seeing, what the caseworkers are seeing, during parenting time, Ms. Brinker's only been able to describe, I'm sure, the tip of the iceberg as it relates to that. I want to express appreciation for the placement in supporting the children and in sharing with the court and the attorneys what's been happening with them at home so that we can best support you as you try to support the children. I'm going to allow the agency to have discretion as it relates to parenting time for Ms. Miller. So what that means is you are free to utilize your twice weekly parenting time if you need to, but you are also free to reduce that if the children's behaviors, if they can't handle it, frankly, and they're clearly communicating with their behavior, and they need to be able to have some time to stabilize. Mom needs some time to work on her case services and to educate herself. She's heavily reliant clearly on the supports at parenting time, and understandably so. These children are very much, they have very much associated we'll call them feral behaviors with their parents because they've been isolated it seems, from many aspects of society. So it doesn't surprise me, frankly, that we're seeing a lot of these behaviors come out the second they see their parents, and that because of that isolation that they had with their parents, and now they're in a completely different environment, that they're able to adapt there. It also speaks to the resiliency of the children and the hope that we can have that they will be able to learn how to function appropriately and keep themselves out of many of the issues that their parents are currently experiencing. That, of course, includes the domestic violence indicators present in the case as well. There are also indications in the court report of use of drugs. So at a minimum, we have one of the children reporting that dad at least blew smoke in his face in order to help him get to sleep at night. I am going to ask both parents to drug test today before they leave. We'll reach out to the pretrial services officer upstairs for purposes of Mr. King's drug test, and we'll ask the case services worker to administer the test as it relates to Ms. Miller, because there simply are I want to make sure that we are looking at all angles in this case, and there are indications that drugs may be a part of the dynamic, and it wouldn't certainly be surprising in a dynamic where you have domestic violence and many other regular hardships to have the use of substances as a way to cope with that, to be perfectly frank. So both parents will be asked to order 2 drug tests today. That's also to ensure that we have safety measures in place around that piece. Obviously, drugs at a minimum, in layman's words, reduce the inhibitions that people may have in making decisions. And where you have these types of dynamics, where you have aggression, domestic violence, we don't need that kind of risk, running that kind of risk amplified by use of substances, whether it's in the courthouse or during visitation or anywhere else for that matter. So for those reasons, both parents are ordered to drug test today. As it relates to the pretrial, certain aspects, obviously, of today's court order are going to apply to Mr. King. His bench trial is scheduled for January 17th, 2025 at 3:30 p.m. That will remain as scheduled. I'll expect you to be ready to proceed on that date and time for purposes of determining jurisdiction. In the meantime, based on many of the observations I've already made, I am granting the department's request to suspend parenting time for Dustin King until the bench trial. In the meantime, I would like to see a referral made for a trauma assessment, frankly, for all 4 children. That includes the oldest child that is placed with his mother. I'd like to see the dynamic between him and his father as well for purposes of the bonding assessment. So I will need Mr. King to be involved with the trauma assessments as it relates to his children, so that they can assess that bond and what that looks like appropriately. And I'll ask you to also ask those parents to weigh in on any parenting time recommendations as they may feel comfortable doing. If they're not, then I'll ask you to find someone else to do a parenting time recommendation. If you find that, again, the behaviors that the children are exhibiting, their need for stability, considering their circumstances where they come from, coupled with fathers' continuously disruptive behavior during parenting time, contributes to a real high risk for these children. A risk that clearly mirrors the risk of harm associated with returning the children to the care of the father at this time. Both parents continue to remain without housing, employment, or many of the other services that are many of the other items that contribute to a safe and stable environment. And then, of course, you have all of the parenting time, the parenting dynamics, or the lack of skills in those areas, as well as the very clear indications of domestic violence, aggression, and other issues in the relationship. All of those risks remain. The children are in the least restrictive placements as of today, and they will remain there pending further court hearings. I will also grant the request of the department to issue an order indicating that Dustin King is prohibited completely from contacting or circling or any other means of harassment to the foster care placement, and I will take violations of that very seriously. Both parents will be subject to the no contact, meaning no contact from mom or dad to the other one. That will also be something that will be obviously have some consequences if that's violated, and I'll trust our service providers to bring that to my attention as necessary. I am also granting the department's request to isolate reports that may be provided during the course of services that are administered as it relates to Ms. Kirsten Miller There's a pending admitted third offense domestic violence case here, which is a felony case.
Yep.
Very well documented instance of domestic violence dynamics here. Power and control dynamics that are happening. So there's no question that we need to isolate reports that one parent could use against the other or vice versa. So that will be something we'll trust our case worker to ensure happens. Of course, the attorneys would be able to review those, but certainly not pass those along to either client. We'll have our next review and permanency planning hearing, frankly, for Ms. Miller on March 10th, 2024 at 1:30 p.m. Again, the first regular review and permanency planning hearing for Ms. Miller will be March 10th, 2025 at 1:30 p.m. Did I address all of the things that you asked me to address, Ms. Thomas? You have a rather long list.
I did, Your Honor, and I really appreciate you taking the time to go through that again. I mean, it may be redundant, but just ensuring that father understands the need to be respectful towards the agency and the caseworkers. I know that oftentimes our caseworkers don't feel that they have any remedy if parents are rude, argumentative, accusatory. And so I just would ask for either the order to reflect that or some guidance from the court about how the workers can feel more protected, I guess.
If it's a danger to meet with Mr. King or it's counterproductive, then really this is going to come back to you, Mr. King, because right now the goal is reunification.
Correct.
And I understand that we don't have an adjudication yet, and you're not ordered to cooperate with anything. But you're going to make it a lot harder for me to understand that it's appropriate for me to return the children to your care if you can't even conduct yourself like an adult with other adults in the room.
Just been trying to let it.
I don't need to hear anything from you right now, Mr. King. I think that's part of the problem that you have. You seem to have an opinion on things at all times, and it would be very beneficial to you if you could sit back and perhaps just listen at times. I wish you the best of luck in doing that moving forward. Unless there's any other questions, that's all for today.
Will the order be emailed or should my client wait?
It'll be ready in a few minutes.